Council, welcome back.
Thank you.
With that, we turn to the final case on today's argued docket from Wyandotte County, case number 127659, Jeremy Filbert, appellant versus State of Kansas appellee. Would the parties please state their appearances?
May it please the court, I'm Jonathan Lawrence on behalf of Mr. Filbert.
May it please the court, the state of Kansas, the appellee appears by and through Deputy District Attorney Kayla Rayler.
Thank you. Mr. Lawrence, would you like any time for rebuttal?
May I please split 10 and 5?
5 minutes are granted.
Do you want an introduction? Actually,
I think it's unnecessary with this case.
Okay.
Yes.
may it please the court. I'm a little split between pointing out this case has already been up here once before. Judge Warner, you were on the panel the first time. I'm split between wanting to point out 3 what I believe are errors or misunderstandings by the district court, and then 3 answers that Mr. Cornwell gave that I think really kind of pull the covers back on why he was ineffective. So I'll start with if I can just highlight the 3 judicial areas, tell you what the answers were, and then we can go from there. On page 6 of 20 on the district court's order, Judge McKissick says, the issue before this court is not to determine the accuracy of Dr. Frazier's testimony. That's something I want to talk about because I think that you can't do a Strickland analysis under either deficient performance or resulting prejudice if you don't look at what Dr. Frazier's testimony was and how it is objectively just unsupported in medicine. The second thing that Judge McKissick said on pages 6 and 7 was the issue for the evidentiary hearing is whether trial counsel's performance fell below an objective standard of reasonableness and did the deficient performance prejudice the defendant. That's the Strickland standard, but that's not what this court stated was needed to be considered by the district court on the remand. What this court said was, under the circumstances, an evidentiary hearing was necessary to determine what strategy, if any, was behind Cornwell's decision-making on the issue. Filbert's proffered expert report on JF's lack of injuries warranted a hearing to determine whether Cornwell consulted an expert on the issue, and if not, why not? And then the last thing in the district court order that really stuck out for me was not so much a criticism, just the fact that the district court noted that Mr. Cornwell did not investigate Dr. Frazier's resume, obtain articles or references regarding her opinion. And as you know from the transcript, he didn't look up any other transcripts, although he had history with her. The answers that Mr. Cornwell gave that I thought were really poignant, and in my estimation, I mean, I know he's got a storied career, but we don't look at, this isn't sports, right? So like, I was a college basketball player, and I was thinking earlier, like I had a game my junior year, we were televised, I went 1 for 12. It was terrible, awful game. But in sports, you don't look at the one game, right? You look at the balance of the season, right? This is the opposite. I don't care if Mr. Cornwell's had 400 trials and he did great. If he didn't do this trial correctly, he didn't do it correctly. Here are the 3 things he said that really troubled me. He did not confer with an expert because Dr. Frazier and the other doctors at Providence, they always diagnose children without injuries as child sex abuse victim. He said that and it was like, what? I mean, the medical significance of there being no injury is that you cannot derive a diagnosis. That's like Dr. Frazier saying Jonathan Lawrence has a broken forearm with absolutely no open fracture, and the x-ray shows no fracture at all. They're completely inconsistent, and that's why he needed an expert. The other answer he gave was with respect to Aaron Miller-Weiss. He says, well, I watched the forensic interview myself. I didn't see anything wrong. I mean, the problem here is you don't know you need an expert until you confer with an expert, right? And I'm not talking about in a red light traffic case. I don't need an expert on ice and snow if it's a sunny, clear day. That's not what we're talking about. We're talking about the bells need to go off when Dr. Frazier in the medical record says, this kid had no observable injuries. I diagnose, not my opinion is, I believe her forensic interview. I diagnose her as a child sex abuse victim. And I'm not trying to be facetious. That's not a medical diagnosis. There's no such illness as child sex abuse victim. That's a legal conclusion. The third answer with respect to the VA medical records, this one's a little closer call. He said, I didn't want the jury to know that Mr. Filbert's ED was not caused by his service in the Navy. That was the ultimate conclusion of the VA hospital, was the causation of your ED wasn't from your naval service. That wasn't the significance of the records. The significance of the records was that prior to this child's allegations, he'd been treated for ED and a serious case of it. I mean, the medical records, and I believe you should have them because there was a discussion on the last 3 or 4 pages of the transcript. Like, I really went out of my way to make sure because they literally were this tall. But the answers are incongruent with what was going on. Of course, we're here to talk about whether the district court erred. An opinion came down May 2nd. I did not think about it in time to provide the panel with it in time to do a Rule 609 letter, but it's an interesting opinion. It's a Wyandotte County case, but it's just something to look at, and it's Betts versus Kansas. It was 126153, and it looks like the panel in this case has pointed out that unlike a jury verdict where you view the evidence in the light most favorable to the state, that's not the burden of proof or the standard in a 1507. It's a preponderance. And so applying the correct standard, I do believe that the district court erred. I do believe that Dr. Gilbert made it abundantly clear 2 things. One, that diagnosis did not follow from those observations.
Counsel, can we talk about how Gilbert was parsing Frazier's testimony? And I guess my concern, or I would ask you, is there a reasonable concern that undermining part of Frazier's testimony is going to undermine the good part that Cornwell wanted to get in, that wanted to get in, that was beneficial? Are you going to throw the baby out with the bathwater? You see what I'm saying?
Yeah, I haven't tried a case in many years. I do all appellate and post-conviction, but I've tried a fair number of cases, and I've given this a lot of thought. Number one, you hire an expert. That doesn't negate the factual underpinnings of, even if you have a Daubert hearing, that doesn't negate the factual underpinnings of the observation. You can subpoena the sane nurse and get the observations, or you can bring in Frazier. And let's just assume for the sake of argument that there was a Daubert hearing and Judge Griffin, who tried the case, I believe it was Judge Griffin, said, you know what, under Daubert, and this is interesting because Mr. Cornwell thought that Daubert was to determine whether or not Frazier was an expert. That's not what Daubert's for. It's to determine whether what she said was science, right? So if Judge Griffin said, no, you can't, it doesn't meet Daubert. That doesn't mean that the rest of her testimony about what she observed, about there are no injuries, that's still coming in. And it could have come in through Dr. Gilbert, right? If he's the expert, you bring him in as a defense expert. You don't need the state to have their own expert if they didn't want to bring in Frazier. What would prevent Dr. Gilbert from testifying? I've been brought as expert to review the medical records. They don't match up with the child's story of repeated violent trauma. She's got no injuries, right? I thought you were going to ask about the 90 to 95% statistic. And the only, I spent a lot of time going through with Dr. Gilbert in the transcript. It comes back to 8th grade science, the scientific method. You can't come up with those statistics. They're absolutely fake. And I hate using that term in today's political environment, but Dr. Gilbert agreed. The reason that you can't come up with statistics like that is you can't have a control group and you can't carry out an experiment on kids. You can't penetrate kids. What's your control group? What's your variable, right? You certainly can't do it with another human being, and you wouldn't do it with anything artificial. So
it's your position that, regardless of undermining Fraser's observations and all these other statistics, you could still get in her medical diagnosis, which is the main thing. I mean, Cornwell testified. I'm trying to be mindful. I know we're streaming, but there was some very beneficial testimony that he wanted out of her based on her examination of the victim. And Cornwell said this was really helpful to our case. So my concern is if you undermine her credibility of all the meaning of those observations, then do you necessarily undermine the credibility of her observation, which is my understanding of what Cornwell was trying to say. I was worried that I was going to undercut the very testimony that I thought would save my case.
Well, two things. I'm not trying to split a hair, but you don't want to keep up. You don't want to get the diagnosis in. You want to get the observations in, right? And the exam was done under her supervision, but it wasn't done by her. It was done by a sane nurse, right? So there are a couple of witnesses, and the fact of the matter is, her observations are the observations, right? I mean, like, there was no other witness the state was going to bring forward to say Fraser's wrong. There were injuries, right? So I don't think, and if I don't have Cornwell's full testimony in front of me, but I don't think he said that he was worrying about parsing. What he said was, well, she said a lot of good things for us. I don't recall him actually even specifying what those good things were. I think we all know it was, there's no injury.
That was the point, is she has these good things to say, and I didn't want to impact, the import of those observations that were so good. Like, if we undermine her credibility, the opinion about those observations, I felt like, or he felt that it would undermine the credibility of her observations, correct?
I don't recall him actually saying it like
that. But isn't that the point?
Well, that's the inference, but all he was saying is, what Cornwell was saying is, well, if you knock out, it was all or nothing for him. If you knock her out, I don't get to say the kid had no injuries. And I think that underscores the ineffectiveness here, not to understand as a trial lawyer, the difference between a factual observation and an expert opinion, right? And that dovetails with what happened with the forensic interviewer. Aaron Miller-Weiss could still come in there and say, I asked these questions, and JF gave these responses, right? And that is admissible. The problem was when the state notifies Cornwell a month before trial, she's an expert, right? This isn't, somebody else drawing it out. This was actually an exhibit that I put into the record. The state designated her on the same form that they designated Dr. Fraser. And so, what we're really at here, if you think about post-conviction, what my job is, when I have to back up an allegation of ineffectiveness at the evidentiary hearing, I have to do what the trial lawyer didn't do. That's how you show the prejudice, right? I go out, I get Dr. Barnett in. Dr. Barnett looks at that interview and says, this kid's, 11 years old when she was interviewed. There's 89 misleading questions. It would be a different situation if Mr. Cornwell said, like in State v. Dull or Dull v. State, the lawyer there testified, hey, I went out and got education in forensic interviewing. I know what to look for, and I didn't see any errors. And then he gave other reasons. Carl says, I'm not a psychologist. I haven't had training in any of the protocols. I just watched it. It looked good to me. And the way the district court got around that is, well, Dr. Barnett couldn't quantify the ratio of the 89 questions versus the rest. Well, number one, you have the record, you could do it. Number two, it was only a 26-page interview. So it's almost 3.5 errors a page. So you don't know what you don't know if you don't confer with an expert. If you don't confer with an expert, like Dr. Barnett, who goes, Mr. Cornwell, there's 89 errors here on an interview of an 11-year-old in only 26 pages, right? So it's the same thing. Like her questions and answers are still coming in, right? There's the purpose of the Daubert hearing isn't to strike the forensic interview. It's to show that an 11-year-old can give those answers if the questions are not properly formatted, right? I think Dr. Barnett could have been hired no matter what the situation was. But when the state goes out on a limb and says, hey, listen, this isn't just a forensic interviewer. She's an expert, right? And the jury hears expert. And then you don't have an expert. It's the same as This is a doctor. Dr. Fraser's diagnosis. These are important words.
We have case law that says that it's not ineffective assistance necessarily out of the gate if you don't provide an expert when the state has provided an expert.
Sure.
Or even if you don't retain an expert to help you understand what the state's expert has said. And here we have a decision by the district court after hearing the evidence at the hearing that the court has concluded that you didn't meet the burden of proof to show kind of a lack of confidence in what happened, that there wasn't a fair trial. As an appellate court, what are we to do with those two things? Number one, it's not necessarily an effective assistance not to provide an expert, and then presented evidence here, and the district court didn't find it compelling.
What I would start with is this. This court's remand had instructions, if you read it closely. This court said there are problems with Dr. Fraser's testimony. We want to know if Cornwell conferred with a doctor, and if not, why not? You can't unring that bell. Like, there are when you have a doctor who gives a diagnosis that plain, that common sense defies, right? No injury, absolutely child sex abuse victim. That's like, your arm looks good and you can move it, broken arm. I mean, it really is that simple. The case law you're citing doesn't say that you never need to confer with an expert. You don't need an expert. Under Strickland, you still have to challenge something like that is that obvious. I think that if I was up
in the district court, I mean, is that obvious? Because didn't the district court also point out that Gilbert admitted sometimes you're not going to have the injury with sex abuse? And the court said, look, it isn't that clear cut because your own expert agreed that sometimes that's true.
He allowed that it could happen, right? But the two things he said was, this diagnosis is wrong. The only conclusion from this diagnosis is child well. That's the medical terminology. In other words, there's no proof. And then the other thing he said was, it could happen that you could have a kid with no injury, but this misleading testimony, about 90 to 95%, it's misleading because there has never been a study, because it's illegal to do that kind of study. In this country, you can't do a study on kids and injure them to see.
But wasn't the study that, I thought the state pointed out, the study had to do with sometimes you can be pregnant and still have that same, present that in the same way. He
said there was one study and it was very flawed. There were only 33 women, and that all of the controls and all of the variables were not controlled. And I was reading this earlier, like there was a problem right off the bat with, he gave an example of two of the women, and now as I'm standing here, I cannot remember what it was about their history leading into the exam, which called into question whether they should have been included in the study, right? But one study is not, I mean, I guess it could have been something argued at trial, but she didn't identify the study. Dr. Fraser, Dr. Gilbert is the one who said, this is what I can surmise, right? I'm thinking she's referring to this one study. But when you look at the overall balance of his testimony, he's really clear. Like, you could have a kid who is molested or even raped, not have an injury. But when you look at this, the allegations here of repeated rape over a 3-year period and no injury, you can't get to the child sex abuse. But Dr. Fraser was real open about it. I based it on the it's in the medical records, on the historical data. The only historical data she looked at was the forensic interview, which means she did an end around of what we don't allow happen, right? It's kind of like State v. El Nicky. You got one witness vouching for the credibility of another. So I do know that there's cases out there, to sum up, that say you're not necessarily violative of Strickland, but what you have here is an expert disclosure with two experts, and he's a storied lawyer. He didn't even pick up the phone to call anybody, especially when he knew this has happened to him and his colleagues in other cases with this medical practice group. That's what makes it different.
I have allowed you a lot of leeway. That's because we've had a lot of questions, and I'll allow your opposing counsel the same grace, but I'm going to ask you to stop
Sure.
right now and we'll come back for rebuttal.
Thank you.
Mhm.
May it please the court. I'm going to focus most of my argument on prejudice. Assuming that Mr. Cornwell was ineffective without conceding it, the real issue in this question is what, if any, prejudice did Jeremy Filbert sustain? Well, looking at the record as a whole, it's none. The defendant in this particular case, Jeremy, admitted that he had sexual fantasies with his, I'm going to say sister because I can never keep stepsister and half sister correct. He told a coworker that he had just met within a day or two. He was having sexual fantasies with his 11-year-old sister. He explained that I can see that she's good for nothing. I want to lay her on her, she's good for nothing but laying on her back so I can come inside of her. And I can see that. There is no reason no other man can see that. He then not only makes those statements to his coworker within a day or two of meeting her, he then asks his teenage brother to go ask his 11-year-old sister to go jerk him off and masturbate him.
But those aren't the crimes that are being discussed here. Those are different allegations of perhaps very poor behavior, but they're not the crimes that are being alleged here.
No, they're not. But it goes to the defendant's state of mind and his intent and knowledge for committing these crimes. That's why we have 6455.
But we're looking at the physical evidence of the crime.
Sure.
And isn't the physical evidence of the crime the problem here? I mean, the physical evidence is Dr. Frazier's testimony. And if Dr. Frazier's testimony is that no injury equals sexual misconduct, and it equals sexual misconduct in 90 to 95% of the time, why doesn't he get a new trial?
I don't think that's her testimony. I don't think that was what her testimony was. She said that in 90 to 95% of cases where there is sexual abuse, there may not be evidence of trauma. That's what her testimony was, and that's what the study was, that there is not evidence of the trauma. I believe that counsel stated that they always diagnose without an injury sexual abuse trauma. That's not accurate. That's not what her testimony was. Her testimony was that we rely on their disclosures on whether or not to diagnose a child with child sexual abuse trauma.
Doesn't that bootstrap in issue number 2? Because the disclosures are the ones made in the forensics interview that your friend on the other side is saying we don't have an expert to discredit. I mean, it goes to the heart of the disclosures. If we've got 89 leading questions to lead her into these disclosures without somebody on the other side pointing out that there could be a credibility problem with the very disclosures that Frazier's relying on.
Sure, except there were not 89 leading questions.
But how do we know that? We don't have anybody on the other side. We don't have any testing at trial of the questions or that testimony presented at all.
Well, if you look at the transcript as a whole of the child's forensic interview, it is clear they're not leading questions because the question right before that is, for example, what did Jeremy do to you? What, if anything, did Jeremy do to you? It's a storytelling. And then the forensic interviewer confirms what the child told her or him, and then says, what, if anything, happened next? It's not a leading question to confirm what the child has already disclosed. If you go and look at each and every one of these leading questions, and
but isn't that a factual question that needs to be tested in front of a jury?
if you have an attorney that is educated and knows what a leading question is, I don't think you need an expert to determine what is the leading question. We all learn it in law school. It's an answer that's a question that supposes the answer. We learn it in law school. You have a learned attorney that's been practicing for a long time, who's done 200 to 300 trials. He knows what a leading question is. And that's what Dr. Barnett's testimony and his opinion is. And the flaw with the protocol is that there were these 89 instances of leading questions. A learned attorney knows what a leading question is. It doesn't require an expert.
Is there a different standard? Wasn't Dr. Barnett's testimony, the heart of it was that there's a different standard when you're talking about the suggestibility of a young person. So in other words, the person who's conducting the interview of the young person does so in a different way because they are more suggestible than someone who is a grown adult who is just kind of used to dealing with leading questions.
Sure. Except that was followed here. The forensic interviewer never suggested an answer before the child gave the answer. the forensic interviewer let the child tell the story in the way that an 11-year-old tells a story and then confirm the details with the next question that they ask. So if you go through the transcript, it's not suggestible. It's not leading questions. It's the child telling the story and then the forensic interviewer confirming what the child had just told her. I also want to go to one thing about issue 3 and the medical records. If these medical records were admitted at trial, it would 100% have undermined the defendant's defense because there is evidence that the defendant did not suffer from erectile dysfunction when he committed one of the crimes charged. If you look at volume 16, pages 115 and 294, he reports that he in October of 2013, he was not suffering from erectile dysfunction. He first reported his issues with erectile dysfunction in November of 2013. If you look at count 5, that entire rape count was charged during the year of 2012. In addition, you have the additional corroborating evidence of what the child victim disclosed, the color of the condoms, that her brother saw these condoms, that there were condoms found in the truck. You have the corroborating evidence that even if it was error for Dr. Frazier to testify that this was a child sex abuse victim, he still can't establish prejudice. In addition, I would just point out that if this court were to grant a new trial, the outcome could significantly be different because here there was the child's prior sexual abuse that was brought before a jury, rape shield. There is potential for rape shields. It can actually be worse for the defendant to be granted a new trial.
It's up to the defendant to make that request.
100%, but it's automatically excluded until he pierces rape shield. So that testimony is not going to come in at all. So his trial outcome can be significantly different if he is granted a new trial, again, because you have rape shield, you have third-party evidence. There was one additional point.
Are those reasons, are those reasons why if we believe that he didn't receive a fair trial, that he shouldn't be allowed a second trial?
No, Judge, I'm just pointing that out that, this is sometimes the dilemma a defendant is in. Does he want to pursue a 1507 based on something that happened in 2016, where there are now different developments in case law that may adversely affect him at trial at a future setting? For example, counsel.
How is it our business we can't make those decisions for a defendant?
No, 100%. And I'm not asking you to.
Then why are we talking about it?
Because it's going into my next point, Your Honor, in that defense counsel or appellant counsel is talking about the expert disclosure of Aaron Miller. Well, but when this case happened, there was no case law about experts in forensic interviewing. That case law came out after this trial, saying that forensic interviewers are not experts. So out of abundance of caution, as is routine practice for most prosecutors during the time before our appellate case law changed, they were filing notice of expert disclosure for forensic interviewers because we didn't have the law. We didn't have the case law to say forensic interviewers are not experts.
It's my understanding that the claim is not that necessarily that identifying her as an expert was erroneous. That's a trial error that would have to be brought up. The claim is that when she was designated as an expert, that should have been a flag for defense counsel to look into this and decide whether you need to retain someone else to help you understand if she's going to be testifying as an expert, the nature of that testimony, and so that you can cross-examine and provide the best defense for your client that you can.
Unless every single jurisdiction was filing a notice to disclose expert for forensic interviewers, because we didn't have the case law to say they weren't experts. If every single case had the same motion filed, let's just even say 5 years prior to
does that mean that if every case had the same motion filed, that defense counsel just had kind of carte blanche to ignore all of this?
I'm not saying ignore, but determine what, again, going back to whether or not they're a new attorney or an experienced attorney, because our case law makes a difference between an experienced attorney and a new attorney. And if they are a learned attorney that has done over, I think his testimony was 10 to 30 child sex abuse cases, you have that experience of the past to be able to help you in the future. Nobody asked Mr. Cornwell at the evidentiary hearing, how many times in the past have you gotten an expert to challenge a forensic interview? That would have been great information for this panel because it would have assisted in determining whether or not it was reasonable, both from the state and from the appellant, but we don't have that. What we have is the record in front of us, and whether or not, because he is an experienced attorney, if it was objectively reasonable based on his experience to not get an expert to go through whether or not these were in fact leading questions or if the interview was tainted. Again, the child told the story, gave the details. The forensic interviewer followed up without any suggestibility. Yes, the question starts off with a leading question, but it's just confirming what was already told to that forensic interviewer. If there are no further questions, I'll stand on my briefing.
Any other questions from the panel? All right, thank you very much.
If please, if I could just hit a few quick bullet points. Let me just clear up any confusion. My client's serving 6 life sentences, right? Like, I'm not worried about a worse outcome. Okay, it just shocks me. Like, oh, maybe he doesn't want a new trial. He's only serving 6 lives. Second of all, there's only one case. I just looked at the table of contents. There's only one case that came down after 2016, and that's Howling. You start with Gaona. All those cases on forensic interviews were before 2016. Gaona's 2012. So Mr. Cornwell was given the disclosure in 2016 of an expert witness designation. He didn't do anything with it. The third thing is, and maybe I'm wrong in this, maybe I'm going out on a limb here, but I assumed going into the evidentiary hearing, as I assume today, that prejudice has already somewhat been decided by this court because under Strickland, the Supreme Court says it's okay to do the prejudice analysis before the deficient performance analysis. And that was the whole point of the first appeal. If you found no prejudice on the record, there wouldn't have been a remand, I assumed, for an evidentiary hearing. I assume that you looked at Dr. Fraser's testimony and said this could be prejudicial, right? And Dr. Barnett's testimony could have been prejudicial. The 2012 count was not a rape. Counsel just said 2012 was a rape. The 2012 incident was an allegation that he put his hand down the girl's shorts sitting outside of a convenience store in a truck. So that had nothing to do with ED. The significance of the ED, the medical records, isn't whether he sustained it in the Navy. It's that you have a guy who comes in front of a jury, right? If you had a jury here, guy's accused of raping this girl. And I don't mean, that's terrible that I just laughed. It's a nervous laugh because there's so much at stake here. But the idea that he's accused of rape and he comes in with his girlfriend and says, I have ED. I mean, like, that is, like, I worried when I first did the 1507, I thought, I'm probably going to get slammed on this for being cumulative evidence, right? There's ineffective assistance counsel cases that say you're not ineffective for not piling on, like enough evidence is enough. And I argued successfully, I imagine, because it was part of the remand, this would be the one case where you do need the corroboration, because otherwise you look like a fool. Like, yeah, I've got ED. How convenient, right? The fact of the matter is these medical records predated his complaints about ED, the treatments. And these weren't, I mean, this wasn't just take a blue pill, right? I mean, like, he really went under some treatment at the VA. The only reason it ended was, you know what? We're not going to continue treating you because we don't believe that you sustained this on the ships. This was a veteran Navy guy. So I do hope that you will reverse. I'm very aware. I mean, like, I've been practicing 33 years. It's tough to come in front of you and say, we need to redo a trial that's 9 years old. But the first appeal was held up because there was, if you look at the timeline, through nobody's fault, but the Supreme Court granted review and then issued an order later, about a year and a half later, saying improvidently granted. Then I was hired to do the 1507. Unfortunately, I had to file it during COVID. Then we had that delay. Then we had the first appeal. I know it's 9 years old, and that's tough, right? Like, evidence gets old, witnesses get old. That's not satisfactory to Jeremy Filbert serving these life sentences. I believe he's entitled to a new trial with a lawyer who will get him the experts, as I tried to do for the evidentiary hearing, which I think satisfies the burden. And I thank you very much for your time.
Thank you very much. And thank you to both counsel for your arguments, both written arguments and oral arguments. We'll take the matter under advisement.